Can you reiterate real quickly your motion to dismiss?
Okay, first, let's step away from the door. How about that? Okay. No, essentially, we have asked the court to dismiss the complaint in this action, the complaint involving the four Archbishop Anthony cases, and that's simply because of the plain statutory reading of the statute, that it did not apply to old cases such as the one that Archbishop Anthony is involved in. And then we've also asked the court to dismiss it because of the fact that it's unconstitutional. It's inorganic. And basically what happens is when there is a law passed, there has to be a retroactive express provision. And so if there's no retroactive express provision, it does not apply retroactively. Laws are intended to apply prospectively, that means moving forward, and not backwards. And that's essentially what the plaintiffs are arguing in this particular case, that somehow it goes backwards. That's it.
No, so judge referred to the 1980 law not being in place anymore, being repealed, and it's not in existence. Can you tell us a little bit further about the different reenactments?
About the legal battle and discussion went over everyone's heads, I am sure. Okay, you know, lawyers and judges, we tend to talk, you know, in our legalese. And essentially the judge was saying, well, the 1980 law no longer exists, right? Because it was repealed by the legislature in place of the 2011 law. And I said, yes, that would be right, Judge, except it only applies to the causes of action that became time barred at that particular time frame. So even though it may no longer exist, there's a new law that took its place, it doesn't completely eradicate or replace the old law that was there for old matters. For new matters, yes, and this is what we talk about prospective application and retrospective application. And so that's essentially the battle that the court needs to determine. He needs to determine the legal issues and see whether or not retroactive application is permitted and whether or not this particular law did in fact do the retroactive application.
Had these victims filed in 2011, would their complaints been valid?
According to the judge.
So after this, you will brief Archbishop Anthony Apuron as to what happened today?
Of course, I brief my client, Heidi. You always ask me about my client.
So how is he?
So how is he and where is he? I speak to my client regularly. That's a nice question there, Crystal. You like to try to trick me there. No, absolutely. My client is doing well. He's looking forward to a determination by the Vatican. The Vatican supposedly is supposed to be making a decision. You all know from the last statement we made on this that there was a prospective, basically, that we anticipate that a decision will be forthcoming.
What happened to Mr. Sandia's case? How come it's not included in today? Was it a jurisdiction issue or is it a diversity issue?
Mr. Sandia is one of the cases that the court has set aside in terms of no preliminary determination of jurisdiction. So the court essentially has said he wants us to look further at the issues of jurisdiction in that case, along with several other cases. His is not the only one, but the ones that I'm involved in, Sandia's is one of the cases that the court said he has not made a preliminary determination of jurisdiction.
But just can you, for the Daily Post, can you elaborate what does it mean when you say no preliminary determination of jurisdiction?
Yes. Jurisdiction basically is a determination of whether or not this court can hear the case. So the District Court of Guam is a very special creature. It's created by statute. So it's basically governed by federal law. So if it does not meet minimum qualifications, the case cannot be heard here. Typically, when you have a cause of action, you can be heard either in a local court or in the federal court. So you have to meet minimum requirements in the federal court to get here.
So what's the issue with Mr. Nicolason? I understand he may have been denied his pro hoc feature for some of the cases.
Actually, he was admitted just this morning. If you go hop onto Pacer, you'll see that the court has admitted him, but only in the Quintanilla case. The court has not received any application or granted any admission for the other cases.
What does it mean since the plaintiff's lawyers said that they would be consolidating? They mentioned something about applying all of the statements to.
Yes. You know, the pro hoc vice admission is a very special admission. Basically, our bar association and the courts like to keep their population to a certain quality and quantity, essentially. And we want people to take our bar here. You have to go through a rigorous exam. You have to submit an application. You have to go through a very long process to be admitted to be an attorney, a licensed attorney on Guam. And so a pro vice admission is basically a temporary admission, and typically it's confined to one case. And so that was the reason for the question. In this particular instance, it was confined to just the Quintanilla case. It was not admitted in all of the other cases that are out there.
Can you speak to Governor Calvo's, I guess, interpretation of the legislature's intent for the law, and why it doesn't apply, why it should not be applied to the case?
Man, you're making me reiterate everything that happened in there. No, you know, basically the plaintiff has submitted Governor Calvo's statement. If you all remember, after the law was passed, he actually issued a statement saying, you know, I believe this. I don't even remember specifically what he said, but I do remember him releasing a public statement following the passage of the law. Well, we objected that the court should consider that in determining what the law means. We told the court basically, first of all, Judge, you're required to look at the language of the law, stick to the statute. And if you want to look at legislative intent, Governor Calvo is not involved in that legislative